So, like usually, immigration tribunals are perceived as a legal space of exclusion. I totally agree with that, and I usually argue that. But today I will tell a kind of different history, and the logic is, well, you know, sometimes these legal spaces are so exceptional that they work. You know, they encompass legality in a way that other legal spaces are not able to do. So I'll talk about interculturality and legal innovation, on how we try to adjust a little bit, incorporate a little bit legal pluralism within the immigration framework. So I will basically do three things. I will start contextualizing what it means, sponsorship, and what it means sponsorship appeals, just to situate a little bit the topic. And then I will talk about three cases, Triple Talaq, snowbirds, and the person who married his wife twice and almost divorced his wife twice. And then I will discuss a little bit the limits and possibilities of legal pluralism within the immigration framework. So what is sponsorship? So Canadian citizen and permanent resident may sponsor a foreign national under the family class. So basically, someone in Canada may import a partner, something like that. There is a certain eligibility criteria, as having enough funds to support the person, and so on and so on and so on. And obviously, the topic here today is more related to the marital status. So what means marriage? So we'll cover a little bit on this. This is basically a decision of the visa officer, so it's not a tribunal decision. And what's happening in sponsorship appeals is that when the visa officer refuses the sponsorship, citizens and permanent residents, they may apply for the Immigration and Refugee Board in order to revise the visa officer decision. So this is important because, well, the appeal division is basically reviewing immigration bureaucracy and not reviewing a decision of their folks in the immigration division. So in terms of relationship in the tribunals, this make a huge, huge difference. So just to situate appeals within the broader framework of the IRB, we're talking about the appeal divisions that deals with removal order appeals. That is a decision from the tribunal. But as I mentioned, sponsorship appeals, we're talking about revising a decision made by a visa officer, you know, in a consulate in Afghanistan. So it's a very different deal. So these three cases, Triple Talaq, snowbirds, and the sponsor who married his wife twice, they are, I'm taking them as sort of ideal types, even if they're real cases. So after, you know, almost 2 years of observation at the tribunal, these are probably the three cases that really made me think analytically about the limits of the tribunal in processing these cases. So the cases. Triple Talaq, you may imagine that this involves a little bit of Islamic law. So we have a situation in which the sponsor met his actual wife abroad. They divorced from his first wife in Canada under Islamic law. So they basically did a triple talaq in Canada. And later on, under Canadian law, more specifically Ontario family law, the Canadian citizen, actually, he married his actual wife abroad after the triple talaq, but before the official divorce. So when he tried to sponsor, he was basically married with two women at the same time. And the visa officer refused the application on the allegation of polygamy. What happened in the tribunal is that the decision maker, the ID member, considered the triple talaq. So basically, we had a very particular judge that was trilingual and trilegal. So they know, she knows some Islamic law addition to common law and civil law, and said, well, makes sense the argument that in order to marry again, this guy that did not have enough fund, they had to divorce under customary law in order to be able to marry again under customary law. So they do a kind of, as she said, a humanitarian divorce, based on the best interests of the child and so on, and granted that. Obviously, none of this is in writing, which raised the questions about the limits of the use of technology and do this kind of research. So I have to be old school and be there during the oral procedures in order to get this kind of nuance. The second case, snowbirds, is a little bit similar. We're talking about a sponsor who met his actual partner abroad. His wife had Alzheimer's and lived in a special care facility. He was still married and supporting her, especially because they lived together their whole life. He sponsored his actual partner, common law relationship. Why snowbird? Because they met abroad in the south of West. He was a snowbird, and he met someone there. And his wife eventually passed away after the application. The visa officer refused the application under the same terms. He was in a polygamic relationship, and worse, he was still supporting and visiting his legal wife during the application. The ID member considered the sponsor de facto divorce, and they put this in writing. So I'm not giving more details on the decision because this can be a little bit problematic, because we have a decision that legally is very problematic legally. So if we can trace a little bit this back through technology, the decision is available online, but I'm not going further on this. Finally, the last case, we're talking about a sponsor who married his wife abroad in Islamic law, filed the sponsorship application, and it's a very interesting case. They realized that the marriage was not valid in African Islamic law, and they decided to marry again. So the issue is that they have a traditional African marriage, and they should have the presence of the mullah supervising all the procedures. And when they refiled the application to validate under Islamic state law, there was no pictures or video of the mullah. So it was not validated. And the rule under immigration Canadian law is to have a valid marriage under state law for the other country. So the visa officer refused the application because they consider the first marriage and not the second one. And it's very interesting because it was not streamlined like that. So when they realized that they didn't have the proper paper after the application, they said, okay, let's try to make it right. And in order to make it right, they had to marry again. And when they tried to marry again, obviously the mullah said, well, I cannot marry you again. You're already married. So what I can do, I can divorce you, and then you can marry again. And then you get take lots of pictures of me, and go to Kabul to try to validate the marriage. So we have all this imbroglio, and all this happened only in a pre-hearing conference, with the wife is in Afghanistan at 3 a.m. in the morning. And the member proposed to consider the marriage status as a conjugal relationship. You made this on the immigration law, you have a kind of common law relationship at proxy, so you don't need to share the same space. You may be in a conjugal relationship with someone from a different country, But basically, the sponsor could not accept it because the mullah was present and calling his wife by something that was not his wife. He could engage in a triple talaq and divorce his wife again. So he was not willing to accept the deal offered by the members because of other kinds of legal constraints. And he vocalizes quite often that, well, you know, I already married her 2 times, I don't want to divorce her again, I have to marry a 3rd time. Right? And again, it was a prayer hearing, so basically the kind of trace you may have from this decision is that, well, the appellant abandoned this case, which doesn't make any sense. Okay? So talking about the limits and possibilities of legal plurality, first, immigration tribunals are space with a largely propensity to face intercultural cases, you know, especially regarding marriage. Why? Because by definition you're marrying abroad. So if they're marrying here, like more likely it's not going to reach the tribunal, and especially if you have less complex intercultural cases, they're going to be accepted by the visa officer. So the kind of cases that arrive there is basically the next complex cases. It's also interesting to realize how discretion plays in a very bad sense regarding deportation. How you may mobilize non-liberal forms of rule, preventive punishment, and so on and so on and so on, but discretion there and jurisdiction over humanitarian compassionate grounds gives more latitude to the decision maker to assess a case under Islamic law and try to adjust this more freely within the immigration law framework. So it's very interesting. There's obviously a matter of recognition, you know, you have to understand a little bit of Islamic law to address the dynamics of an Islamic divorce and a second Islamic marriage. And to a certain extent, there are some members able of doing this kind of intercultural, interlegal reading of complex cases. We have different levels of descriptions, so all this, they float in different levels of legal descriptions, so how you address customary practice and indigenous practice in some cases. So sometimes it's not only a matter of, you know, colonial reinvention of indigenous practice as customary law, but you may have something more related to indigenous legal traditions abroad and can be very messy. And finally, you may have this kind of compromise, they go on both senses. And you may have resistance from the immigration law side and as well resistance from the other legality, as in the third case. So I'll stop here. So the idea is just to show a little bit on how these things are more complex and on a way on how exceptionality may also be a kind of open door to legal innovation by no attendant means.